you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Oppression and cruelty can't last forever, even for cops. Once they cross the line, justice catches up. Just like in these cases where the cruel officers finally got what they deserved in the courtroom, proving no one is above the law.
You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd.
Courtrooms are places where you see cops in their most miserable states. Their actions finally catch up to them, and now it's time for the consequences. Starting off with the cross-examination of the officer involved in George Floyd's death.
You were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't shoot me, man, I don't want to get shot," right?
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air?
Yes.
And then you told him to put his hands on the dash, is that right?
That's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Fallen, yes.
And then the other officer with you on the other side of the vehicle changed that to put your hands on your head, correct?
That's correct.
They did all that and didn't investigate anything. Humanity and basic human decency were not in these cops' dictionaries.
Was he awake during this incident?
Yes.
He was conscious?
Yes.
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was talking to you, he was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
She's asking these questions to make it clear that Floyd wasn't drunk, sick, or had medical issues. While he was talking to them meant that he was sane and posed no threat.
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
You were asking questions about what the other officers were doing, correct?
That's correct.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop dead while you were interacting with him, correct?
No.
Thank you. Nothing further.
Basically, two officers at the scene gave two different commands to Floyd, hands on the dash and hands on the head. He can only do one, so they used this trap to drag him out. Eventually, this cop was sentenced to 21 years in prison. This officer certainly earned his karma, but things took a bizarre turn when this next cop's qualified immunity was revoked.
He had nothing in his hands, and he was shot twice and killed.
A routine traffic stop in 2011 ended tragically when Officer Osvaldo Villarreal fatally shot Benny Herrera, an innocent man. Years later, Herrera's family sued the officer, and this video documents a pre-trial hearing related to that lawsuit.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
backwards. But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Shooting man in seconds? Cops these days really don't have the guts to investigate. They are so scared out of their minds, everything seems like a threat.
His camera was turned on, but
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
And to top it all off, his PD cleared him of any wrongdoings. The system does support corrupt pigs, or else this one should have been fired that exact day.
Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make that decision.
Well, don't we have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities.
The body cam footage made it very obvious that the officer was in the wrong, and the judges also felt that his qualified immunity needs to go.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. How is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Villarreal got off easy, basically. No real reason for the shooting, but he's still on the force. Go figure.
It seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not a jury redo. We have to determine based on the facts as alleged by the plaintiff. And
Right.
they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension, they rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
But this tyranny wouldn't last long because the expectations of the victim's family were high.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, if we take those facts, you're saying that as a matter of law, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed. But that's not the same thing as saying he wasn't armed.
The judges argued that the officer should at least be tried, as the other party had substantial evidence to challenge his qualified immunity.
Espinosa, the suspect, had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The defense tried everything, but the judges weren't having it. At least he didn't plead insanity like all the other cops do.
Here, the domestic violence incident was over.
Yes, and there.
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
Fully on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here has raised about the fact he didn't have a gun.
I understand. The trial court did.
And both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The cop had no need to escalate the situation. He could have just taken a chill pill and relaxed himself and the people he was supposed to investigate.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Both hands were visible, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available.
No matter what the defense argued, the facts were clear. Herrera was dead, and Officer Villarreal was responsible for his death.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
The jury has to decide the underlying predicate facts.
I understand that, but I think I'm arguing on your point, if we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
at that point, I got the answer. Right.
Finally, some justice for Herrera. Officer Villarreal's qualified immunity was revoked and a trial took place. The court ruled that he had used unlawful deadly force. The city also paid Herrera's family $1.4 million in compensation as the case proceeded to trial. This next sorry cop was also being questioned for excessive force.
Did you apprehend good guys?
Detective for him.
Never. I take that back. I bit a victim one time because she jumped in front of me.
Do these cops not have any trigger discipline? Daytona Beach PD officer Joshua Mercereau was in a gunfight with Marvin Jones. Jones got hit 5 times, and his girlfriend, Aviana Bailey, got caught in the crossfire. She's paralyzed from the chest down now, so she's suing.
Playing, fumbling, doing something with in his lap. There's none of this, there's none of this, it's this. And he's looking at me the whole time. And then it happens.
What happens?
He sticks the gun out the window and points it at me.
Okay. How does he stick the gun out the window?
If I'm sitting in the driver's seat, where would my... So he just went just like that.
Okay.
And it was between the mirror and the A-post.
Okay.
Well, actually, if I'm driving...
Exactly.
I'm sorry. If I'm driving, the driver's side is... The door is here. So he did this.
Okay. Because you had him moving...
Excuse me.
...further into the passenger compartment.
No, that was completely...
Right.
That was my mix-up in the side. It was the right side that he did it with, and then he put the gun between the window.
Officer Joshua couldn't even get the story straight. All of his memory issues are going to pop up right now.
You said right side again.
Left side. I'm dyslexic.
Are you dyslexic?
No,
Okay.
I'm sorry. I didn't. That was a bad joke.
Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area, right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least 1, and possibly 2. I can't count them. I can't tell you how many exactly I saw.
The man shot a guy 5 times and sat there like he was at a coffee date with his friend. He showed 0 signs of remorse.
I was committed to engaging him, and I did that. At which point, my ankle rolled off the curb, and I fell on my back.
Okay.
I was falling and still shooting, so somehow the gun jammed from limp wristing it.
Okay. Fired at you, or you saw several muzzle flashes?
Yes.
Okay. How do you define several?
Objective form.
1 or 2. 2 probably.
Okay. Several's not 1.
Yeah.
We agree to that. Do you mean, is several more than 2?
Objective form.
I would say 2.
Okay.
So we'll say a couple.
Okay.
Investigators pressed Joshua about the tragic incident, but he continued to make light of the serious situation, attempting to joke instead of addressing it responsibly.
In your deposition, you discussed dust. Tell me about that.
Form.
Was there dust at scene 2?
Yes.
Tell me about that.
Form.
There was dust at scene 2.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes, from the suspect's vehicle spinning in the grass, which was dry.
Did the dust settle? That's what we say. Before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
When did the dust settle?
Objective form.
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. Before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out.
Joshua had no remorse for his actions, and as the deposition continued, his answers were about to get even more weird.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
There was none.
What threat to an officer or other was posed when you got out of your car, when you took a step towards the Lincoln?
Objective form.
At this point, the defendant's actions.
Which were what?
Fumbling around on his, making very furtive movements.
The attorney then questioned Joshua about his troubled past, which included being removed from his role as a canine officer.
Did you have your duties as a canine handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form of objection.
In my opinion,
Yes.
I was doing my job too well.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me.
Because your dog got him?
Because we got them as a team.
Okay.
If you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension. So they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say.
Okay.
Which never made any sense to me.
This cop was downright dirty and arrogant. These are exactly the kind of people you don't want on the force.
When was your canine handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Why does that date stick out?
Worst day of my life. I enjoyed the job. I would have paid the city to come do that job. Tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
Detective form.
Never. I take that back. I bit a victim one time because she jumped in front of me. So I did. I bit a victim one time.
Was that another officer?
No, it was a victim, a domestic violence victim.
Joshua's history was riddled with poor decisions and excessive use of force. The attorney dug deeper, exposing his psychopathic nature.
Do you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that and tell you did that portion incorrectly?
Yes, sir.
There was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Tell me about that.
He was, Roe. He was hammered. He was drunk.
Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident? What happened there?
I was on K9. We were looking for, they're twins, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did?
No.
The one of them
had a felony warrant.
The guilty one, not the innocent one.
So the mother's there, and got the place surrounded, and basically she said, "You're not coming in." Well, he's in there. We can see him in there. We can force entry on a felony warrant. I eat that one. That was my responsibility all day long, for not knowing that it's the brother. They do look different. If I had seen his face, maybe paid attention to his haircut.
Did you ever arrest a good guy? Form.
Did I ever arrest a good guy?
Yeah.
Wait till you see what sentence this next cop got after the horrible crimes he committed.
My wife took her life. My will to live went down significantly.
Today, we'll be diving into one of the most jaw-dropping stories yet. Corrupt cops who never saw it coming. In a twist of fate, these officers, once seen as untouchable, are now facing unexpected prison sentences, and their reactions are nothing short of explosive. In February of 2021, when the police got to the house of former Marine Daniel Howard, they discovered his wife dead in the bathtub. This caused things to get out of hand, and Howard ended up in court. We bring you footage from his sentencing where he would receive the punishment for his grave crime.
Your Honor, I'm not that monster. I assure you that people are portraying me to be. Kenny and I had 28 years together and raised a family, had mostly a good marriage and a good life. I worked away from home all the time and I was gone. And
It would be foolish of Howard to think that anyone would buy a bit of this. He was committed to his act, though, that's for sure.
I was gone. But I'm not that animal that they portrayed me. And I lost her. And I couldn't have been that monster for 28 years and not be here before the court, waiting for him. It is not my intention to anger the court or disrespect the process that I used to believe in and work for. But Your Honor is about to sentence an innocent man to prison. And I love my wife.
Even I can see through this horrible murderer's crocodile tears. He simply couldn't handle the fact that he had been caught red-handed.
And I love my in-laws, Jamie and Wendell, and my stepdaughter, Brooke, who I raised since an infant, and her daughter, Kinley, that I helped raise for 5 years when we took him into our house. And I will miss them very much. I do miss them. Words cannot describe the pain that I feel for that. I stand before you, shell of a man who used to be. Hell, I don't even have a shell left.
This disgusting killer was just unable to halt his own pity party, even after being proven guilty.
My wife took her life. My will to live went down significantly. And when the jury found me guilty of crimes I didn't commit, it went down even further. Mr. Johnson touched on this. I'd appreciate the court taking into consideration my service to the country as a Marine with an honorable discharge.
I can tell how guilty this man is just by the fact that he brought up his service in the hopes of gaining some leverage.
Service to the community through coaching football and baseball for many years and being a 4-H leader for many years. We provided 1,000 animals to kids in this community that take to the fair and show. We were very involved. I volunteered to help the seniors in the community north of me. Every time there was a windstorm, I'd cut trees from the driveway, from around the house. I volunteered a lot. And to the frustration of my wife sometimes because I was gone even more away from home.
Did he truly believe that he would succeed with all of this acting? The only place he would probably be going would be a jail cell.
I just want to reiterate that I still love Kennedy's side of the family, Jay, Wendell, Brian. I still love my stepdaughter. I miss them very much. I love my side of the family, my son Wyatt, my dad John, my sister Diane. I will miss them very much. Thank you, Your Honor. That's all I have.
Thank you, Mr. Howard.
The judge then chose to speak. What he had to say will astound you.
We're here for sentencing on a conviction of second-degree murder and a conviction of domestic violence, a felony. And what the jury found, Mr. Howard, is that you murdered your wife. Now, why they found it a second-degree murder versus first-degree I'm not there in the jury room, but they didn't find beyond a reasonable doubt the one element of premeditation. Part of the jury instructions that you asphyxiated your wife, that you strangled her, that you killed your wife.
Howard's hope for freedom and mercy were dashed when the court ignored him right away. This murderer is unworthy of mercy. What type of man doesn't even spare his own wife?
The state has argued a lot about, we don't know exactly what happened that night, how she obtained the bruising, the burn, the broken jaw, and your attorney disputes the state's version of how she got those injuries. We don't know for sure. But what we know, beyond a reasonable doubt, is that you strangled your wife, you murdered her, and then you staged her naked body in the bathtub, shot her through the mouth, and tried to pass this off as a suicide.
It's absolutely terrifying how unethical and evil a man must be to do this to anyone, much less his own spouse.
Often in horrible crimes like this, everybody wants to know why. And often we don't know why. And I can't get inside your brain, but the pretty clear evidence, I agree with the state, is that this was due to jealousy, greed, pride, anger, revenge, some combination of that. And because of that, you killed your wife. And you killed her in a brutal manner. You killed a mother. You killed a grandmother.
Although the judge respected Howard's service, he was now determined to teach him a lesson in justice. He couldn't let his horrific actions slide.
We don't have to know the answers to all those other things to understand this was a heinous, outrageous murder. From my view of the evidence and from what came out, despite your efforts at the time to appear emotional and sad and distraught, it's clear to me that you're a remorseless killer. And I don't say that lightly. I don't say that lightly at all because we don't like to think that anybody would be like that. You're not sorry.
As he ought to, the judge accepted no nonsense at all.
The way you treated her family, the way you treated your own family, your own stepdaughter, your granddaughter, with a cold and callous contempt after the murder, it belies your argument to me today that you love these people and that you're sorry. As Brooke indicated, you never even talked to her about this after the fact. Your behavior towards her was contemptuous and unkind. And I'm not sentencing you for that. There was a lot of stuff that came in at the trial as to how you treated people after the fact.
Any life Howard had created had been destroyed along with all of his hopes.
In terms of protection of society, obviously society has to be protected from somebody who's willing to commit the ultimate crime of murder. I was just say, if they feel threatened, you didn't even feel threatened. This is over, again, most likely, elements of greed and anger and revenge. Someone who responds to, I understand your wife was leaving you after many years of marriage. Your wife had engaged in a relationship with another man, and you were getting divorced.
Just wait till you see what's next. Daniel Howard's sentencing.
Sometimes the nature and gravity of the offense standing alone is sufficient to justify a fixed life sentence. And that is what I'm going to impose here. I think Kendi's family deserves to have that closure. The crime is so egregious that I don't think you should be released at any point in the future. And I don't impose that lightly. So I do find that a fixed life sentence is appropriate for the count of murder in the second degree.
First District Judge Lamont Burek sentenced Daniel Howard on Thursday to life in prison without the possibility of parole for the murder. Daniel Howard also received a 10-year sentence for domestic battery, which will run concurrently with his life sentence. In this next case, a county sheriff who thought he was above the law was given a massive humbling in court.
Approximately how many rounds of ammunition did you find?
Approximately 5,000 rounds.
What caliber?
Various calibers.
In April of 2024, Todd Brown, a former FBI agent, testified about his search of 4 in Jamie Knoll's residences. Former Clark County Sheriff Jamie Knoll was accused of having staff from the sheriff's office work at his barn and using a business credit card for personal transactions. But you will be amazed at just how corrupt this officer was.
We had contacted Mr. Todd Brown, a retired Federal Bureau of Investigation officer, who we asked to conduct the search. Mr. Brown conducted the search, and pursuant to the court order, we filed on May 1st a copy of the report along with an exhibit that identifies all of the items that Mr. Brown located in the house. We would like to call him as a witness, Your Honor, to have him detail for the court the location and the items that were taken.
You may.
Thank you.
Mr. Brown? Please have a seat. You raise your right hand. Do you solemnly swear or affirm under the penalties for perjury testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Your Honor.
Thank you. Have a seat. Your witness, Mr. Boyle.
Thank you, Your Honor.
Todd Brown would share some startling discoveries he made during his search.
Mr. Brown, when I contacted you, I asked you if it would be within your capacity to do an inventory of all our client Jamie Knoll's properties that he owned for the purpose of securing any additional weapons that might be there, even though the court didn't authorize that, also to indicate whether any ammunition located in those locations. Is that correct?
That's correct.
Also, I've asked you that you were aware at the time that you were going to do the search that Mr. Knoll was given permission by this court to have a shotgun at the residence. Is that correct?
That's correct.
Okay.
However, more firearms were found at Jamie Knoll's residences besides a shotgun. Additionally, something even more significant was discovered.
Well, let's start with what properties were you assigned to search?
I was assigned residence at Old Tay Bridge and a pole barn with a cabin next to it at, I believe, 709 Old Salem Road in Jeffersonville. The residence was also in Jeffersonville.
Okay.
Then a green barn at 711 Old Salem Road, and then a house on Turnberry. I believe it was 2408 Turnberry.
Also, they were also located in Jeffersonville?
Yes, all the properties were in Jeffersonville.
Were you able to locate any weapons in that home?
I did.
And what did you locate?
I located a Glock 26 pistol, semi-automatic pistol, a Sig Sauer 1911 semi-automatic pistol, and a shotgun.
Okay, let's be very specific on the first, the Glock 26. Did you also take a photograph of where that was located?
I did.
Okay, could we have a picture up on the screen which would be for the purpose of having you identify the area where that weapon was found, is that correct?
Since no one else was able to discover this slimy cop's secret hiding places, they did well to hire a specialist to look into it.
Where was the gun located?
It was located...
Why don't you come off the stand if the court would permit and point to the photograph?
It was located in with all these items that are shoved into the closet area here.
Was it on the floor? Was it in an item, or where was it?
Actually, at the time that I located it, I was pulling items out of the closet, and there was a nylon zip case and I opened the nylon zip case to see what was in it, and that's when there was a gun box inside the zip case. I opened the gun box, and the gun and one magazine was in the box.
Was the weapon loaded or unloaded?
It was unloaded.
Can we show the second photograph, please?
The handgun was obviously concealed in the closet by Noel. Though he believed it would not be discovered, he couldn't have been more detached from reality.
You also, as part of your search, in searching all of the house, went to the master bedroom.
I did.
Okay, and is that the photograph of a closet located in the master bedroom?
Yes, sir.
Okay, and was there a weapon located there?
There was.
And what was the weapon?
It was a 6-hour 1911 semi-automatic pistol.
Okay, and where was that weapon located?
It was located in this area of the floor. There was a pile of stuff on the floor.
Was that pile on top of it?
I'm sorry.
I couldn't see.
I'm sorry, sir.
If you'll do that again from the other side.
No, I'm sorry. I located it in this area of the closet. There's a pile of clothes and all sorts of stuff there on the floor, and I found it as I was pulling stuff out.
Noel had just gotten himself into needless trouble when he ought to have followed the advice of the authorities and retained the shotgun strictly for self-defense. He would soon pay the price for defying orders.
Approximately how many rounds of ammunition did you find?
It would be a really rough estimate. I've detailed it in my report. Approximately 5,000 rounds.
What caliber?
Various calibers. They're 9mm, 45, 380, 5.56.
It is absolutely crazy if the real number was even close to 5,000. With so much ammunition, was he going to rob a bank or what?
7.62. That's 22. And there could be others. That's what I recall.
The two guns that you found, the Glock and the SIG,
Yes, sir.
were you told where to look for those?
No, sir.
Nobody told you to look in the master bedroom closet or the laundry room closet?
No, sir.
Did you have any contact with the defendant, his wife, or his daughter?
With his daughter.
Which daughter?
I think Grace.
What was the extent of that contact?
Just to advise that I was at the home.
Had you ever met?
To conceal it, he most likely moved everything he owned that was in the cars inside the house. However, unfortunately for him, his party got busted and everything was discovered.
Do you recall off the top of your head what vehicles you searched?
There was a Trans Am and a BMW at the residence. Then there were several, what I would call classic cars, older cars, at the pole barn at 709 Old Salem Road.
Several, more than 10, less than 10?
So to find a service revolver, I keep saying revolver, service firearm, in a duty belt with other mags, that's not too far-fetched to believe that one would know where that was at, would it?
It was funny to watch how the judge was subtly criticizing Noel. Of course, Noel was aware of the whereabouts of all his guns and ammo. He should have turned them in, but chose not to, and now he would pay the consequences.
Rhetorical question you don't have to answer.
Yes, sir.
Just reinforces my decision to impose sanctions. If that prompts any further questions.
None from the
Not-
defense.
I do have. The Remington shotgun, was it in a box when you found it?
No, sir.
Was it near a box? A Remington firearm box?
Not that I recall.
Did it still have tags on it?
No, sir.
Actually, Noel probably had no intention of using the shotgun for self-defense.
Where was it at?
I located it in the basement, what I generally term the theater room.
And not loaded?
No, sir.
Not much use for self-defense, is it?
No, sir.
You were in the upper area and you needed a firearm for self-defense, where would you go of the ones you found?
The closest one would be the 6R 1911.
Okay. No other questions? That prompts any questions.
One question, Your Honor. Mr. Brown, was there any 12-gauge ammunition found?
Yes, sir.
That's all, Judge.
Mr. Boyles, I'm not going to impose any further sanctions today because it was not certified to me that there was no further firearms. But after today, if there's any further firearms found, there will be additional sanctions. So if your client needs to tell you something, he needs to tell you right now. You need to take a few moments and ask.
I'd be happy to, Your Honor.
The judge was absolutely bossing and grilling Noel and his lawyer, for good reason.
Why don't we go off the record so he can speak with his client?
The one thing we would add, Your Honor, is the duty weapon.
Let us get back on. Okay, we're back on that. Go ahead.
The only thing we could add, Your Honor, is there's no weapons in the house now, and the duty weapon was seized on the original search. It was in the console of his car.
Okay.
So the one that was found was not the duty weapon.
Okay.
Thank you.
Of course, after a search by a real retired FBI officer, there wouldn't be any weapons. I doubt there was anything that was left hidden from him.
I have no questions.
Why was it in a service holster with additional mags? And you don't have to answer that.
Well, because I don't carry guns, so I don't know, Judge. I got a BB gun.
That's all right. Mr. Brown, thank you. And thank you for conducting the search for me. I appreciate it. Your excuse.
Thank you.
Noel now begins a 15-year prison sentence with 3 of those years suspended to probation. With approval from the judge, Noel will get credit for time served beginning June 8. Per state law, Noel could shave time off of his sentence with good behavior in prison, leaving him to serve roughly 9.5 years behind bars. If you enjoyed this video, make sure to leave a like and comment down below with your thoughts. And if you liked this video, you'll love this next one where these cops catch twisted predators in the act.
You sent your to her, didn't you? Let's be real. Yes or no?
Yeah. I'm sorry.
Why did you do that?
I don't know what the fuck is going on with me. I'm sorry.